All right, ma'am, your Trinity Bell.
Yes.
And this is cause number 25 DCCR 1381. I'm going to reset, just a normal reset to give you guys time to get it filed down in misdemeanor court, get that taken care of. If everything gets taken care of and you go to court down there, then you probably won't have to come back to this court date. Your case will be dismissed. Unless you hear otherwise, though, plan on being back here unless Ms. Holmes or your bondsman tells you you don't have to, okay?
Yes.
All right.
And
Thank
we
you.
had one, Ms. Bell has been wearing a GPS ankle monitor.
Hearing starts with a small victory, Trinity Bell. The judge agrees to remove the GPS ankle monitor. But notice the important catch. Freedom from one bond condition doesn't mean freedom from all responsibilities. The court immediately shifts focus to another requirement she hasn't completed yet. This is a classic courtroom reminder that compliance isn't optional. Judges often look at the entire picture, not just one issue. Have you ever seen someone celebrate too early before realizing there was still more work to do?
For quite some time, and we were wondering if the court would allow her to have it removed. Or
Let me look real quick. I don't know that I have any notes on it. Any issues?
who's your prosecutor down?
Mr. Smith?
Judge, we're not opposed to it.
All right, so Ms. Bell, I'm going to remove that condition of your bond that you have to have. Well, actually, let me make sure first that it's a condition of the bond and not the bondsman.
Oh,
Because if it's their condition, that's up to them. If it was the court's condition, I can change it. And I forget to look at that sometimes, and they get very mad at me. Let's see if I can figure this out.
This is one of the most important moments in the entire hearing. At just 18 years old, Daniel Hayward is being offered something many defendants desperately wish they had: deferred adjudication. If he follows every rule, pays restitution, and stays out of trouble, he could walk away without a conviction on his record. But the opportunity comes with pressure. One mistake could send him right back before the court. The question is, will he treat this as a second chance or a warning shot?
What would we do is probably just get it touched on those and then just. I mean, they don't really do it, like that, which we can just ask for a post to. This is a short, sweet person that's getting. Yeah, better.
I don't see that I don't see it notated on the magistrate's warnings. Yeah. Okay. There we go. Right there where it says bonds.
Notice how the judge isn't just focused on punishment, she's focused on accountability. The restitution order ensures the victim is compensated for losses, and she's making it crystal clear that waiting until the last minute is a dangerous gamble. Many probation violations don't happen because someone commits a new crime. They happen because people ignore financial obligations, paperwork, or court conditions. Sometimes the smallest requirements end up causing the biggest problems.
It's there, it's mine, it's a court bond. Okay, so then, our court condition. Have you been going to, did you go get an assessment? Have you been going to spinal top like you were supposed to?
I lost my job, so I don't have any insurance anymore.
Well, that's the nice thing about spinal top is you don't have to have it.
Okay. Well, I just need to know for getting an appointment for it.
Okay, so that was also a condition of your bond, that was set, and so it's very important that you still follow through with that. So even if it's gonna be a misdemeanor case, you need to go get that assessment done, call and make your appointment.
Now the hearing takes a dramatic turn. What appears on paper to be a single felony charge suddenly becomes much more serious because of prior convictions. In many jurisdictions, repeat felony offenses can trigger enhanced sentencing ranges that completely change the stakes of a case. Listen closely to the defendant's reaction. He's focused on having already served his previous sentences, while the judge is focused on how those convictions affect the current case. That's a distinction many defendants don't fully appreciate until they're standing in court.
So that you can get that done before we have to hear that other stuff, okay? But I will remove the GPS monitoring device condition today. Ms. Holmes can tell you, y'all can talk about how to do the spinal top thing, but I'll remove the bond condition of the GPS device today. All right? Okay, stay in touch with Ms. Holmes. Daniel Eli, Ms. Holmes.
Your Honor, may I approach your man?
Sure.
That's why I came to talk to Ms. Holmes. We should be able, it's gonna be dependent upon what happens down the hall.
Okay, Mr. Hayward, in clause number 25, DCCR 1346, the state has elected to proceed on the lesser included offense of a Class A misdemeanor, attempted burglary of a building from August 29th of 2025. And how do you plead to that charge?
This exchange highlights one of the strictest conditions courts impose in family violence cases: no contact orders. The defendant tries to explain that the alleged victim initiated the conversation, but the judge quickly shuts down that argument. Legally speaking, the responsibility falls on the defendant to obey the court order regardless of who makes the call. The judge's message couldn't be clearer. Hang up immediately or risk losing your bond and returning to jail. Do you think most people truly understand how strict these orders are?
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablets documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand that if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,620. Is that your understanding? And are you a U.S. citizen? State Condition number 1.
No objection.
It's admitted. Is there any evidence Mr. Hayward's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty.
As today's docket comes to a close, a pattern emerges. Nearly every defendant was given time, opportunities, and clear instructions. But every opportunity came with accountability attached. Whether it was hiring a lawyer, paying restitution, following probation rules, complying with GPS monitoring, or respecting no contact orders, the judge repeatedly emphasized personal responsibility. Court hearings like this rarely generate headlines. There were countless cases are quietly won or lost long before trial ever begins.
However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to follow all of the rules and conditions of probation, and you're ordered to pay that restitution in the amount of $2,620. If you do everything that you're supposed to on this probation, get the restitution paid off, this is a great opportunity because you don't have a conviction on your record. And if you satisfactorily complete probation, at the end, the case gets dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, then you can be brought back into court, found guilty of the offense, and go to Jefferson County Jail for up to 1 year. Do you understand? So $2,600 is a lot to pay in 2 years. How old are you? 8, so you're very young. It's very important that you make payments on that every single month, even if it's a little bit, because it'll add up. All right, so some people think, well, I'm going to get a better job, or I'll sell this, or I'll get my tax refund, I'm going to wait to pay it, and then